The FIR was lodged as per the agreement condition. Page number 15. કે સર કેસ એવો કે મારો છોકરો મારો દીકરો ત્યાં સ્થળ પર મળી ના આવ્યો એટલે મને એવું ડાઉટ છે કે એને મર્ડર કર્યું છે. Sir, this is father, accused son, complainant mother, witness sister. As per the case of the person, he is not eyewitness. Complainant is not eyewitness. His mother is not eyewitness. His sister is not eyewitness. Yes. Still, there's a clear message. Page number 15. Formal unit, એટલે પેલું એસ પર રૂટીન કે ત્યાં જમવા આવતા હતા ફરિયાદીને ત્યાં એટલે એમને ફોન ના પડે એટલે પછી આ ગભરાય ને આપણે જોવા પડે એટલે પેજ નંબર 15 પર આખી સ્ટોરી છે એમની. તમે માની હતી કે રુચિ તથા બહેનનો દીકરો મનીષભાઈ આ વખતે 108 એમ્બ્યુલન્સમાં ફોન કરેલ અને બાદમાં પોલીસ કંટ્રોલ રૂમમાં ફોન કરેલ હતો અને 108 એમ્બ્યુલન્સ આવતા મારા પતિને ચેક કરતા મરણ ગયેલાનું જાહેર કરેલ. મારો દીકરો હાજર મળી આવે ન હોય તેથી ત્યારે જ મારા પતિને મારી નાસી ગયેલું છે. ફરિયાદ જે છે સાહેબ ખાલી અનુમાન ઉપરથી આપવામાં આવેલી છે કે છોકરો ત્યાં હાજર નહોતો એટલે ફરિયાદીને એવું ડાઉટ ગયો કે ભાઈ આ હાજર નથી એટલે એને જ મારા હસબન્ડને મારી નાખ્યો છે અને નાસી ગયો છે. Yeah, as per the FIR and all the investigation paper and the affidavit of the investigation officer, complainant is not eyewitness. Complainant is the mother of the accused, wife of the deceased. અને જે સાહેબો તરીકે બતાવેલા છે એ બી સર આઈવિટનેસ નથી as per the FIR and as per the affidavit of the investigation officer. ફરિયાદી આપણા સાહેબ એફિડેવિટ છે એ અમે કામ ઉપર છોડો છો નામદાર કોર્ટને yes. incident was occurred on 28 June 2025. The applicant was arrested on 2nd July 2025 after 45. I put this one report. I know the reason way. Arrested the attitude of the complainant, his mother, and witnesses. This study also. Yes.
ફરિયાદના પહેલા નંબર 2 તારીખ 27/6/25 ના રોજ બપોરે રાત્રે 1 વાગે મારા પતિ મેરેજ થઈને આવી જમવા માટે વૈભવ સાવંતથી શીતલપાડ ખાતેના મકાન ખાતે આવે અને જમીને વૈભવ સાવંત ખાતેના મકાન ખાતે આવે એટલે વખતે મારા દીકરાએ ઉપરોક્ત મકાનનો મુખ્ય દરવાજો અંદરથી લોક કરી દીધેલ અને ડોર બેલ વગાડવા છતાં ખોલે નહીં. જેથી આશરે 2 વાગ્યા આજુબાજુ મને ફોન કરી વાત કરી. બાદમાં સાંજના 6 વાગ્યા સુધી દરવાજો ખોલે નહીં. જેથી મારા પતિએ ફોન કરી દરવાજો ખોલવા માટે કારીગર બોલાવે અને મિસ્ત્રી દ્વારા લોક તોડાવે અને ઘરમાં પ્રવેશ કરેલ હતો. આ આગલા દિવસનો બનાવ છે. એના ફાધર અને મધર અને આ ડોટર એ ત્રણે અલગ રહેતા હતા અને આ દીકરો છે અહીંયા રહેતો હતો. ક્યારેક ક્યારેક જવા બનતું હતું. પણ આ દીકરો છે એ પહેલા નંબરના પેરામાં જોશો તો મારો દીકરો નામે ચોથી લીટી સાહેબ પહેલા પેરેગ્રાફની ચોથી લીટી ફરિયાદની મારો દીકરો વરુણ રોની ઉંમર વર્ષ આશરે 29 નો જે છેલ્લા 7 વર્ષથી અમારા પરિવારના કોઈ સભ્યો સાથે સંપર્ક રાખતો નથી અને ઉપરોક્ત મકાન નંબર B801 વૈભવ ટાવર ખાતે રહે છે અને બેડરૂમમાં જ રહેતો હતો. જેના કારણે તેનો સ્વભાવ પણ એકદમ ગુસ્સાવાળો અને જનૂની થઈ ગયેલ છે અને રૂમની બહાર નીકળતો નથી. જમવા તથા બેસવા બાબતે અમારી સાથે અવારનવાર ઝઘડો કરી ઘરનો સામાન તોડફોડ કરતો. દર માસે મારા પતિ પાસેથી ખર્ચ કરવા માટે બેંકમાંથી પૈસા લે છે. જમવા માટે ફૂડ ડિલિવરી એપ્લિકેશન સંપર્ક કરી રાત્રિના દરરોજ 12 અને 1 વાગે ડિલિવરી કરાવે છે અને અમારી સાથે છેલ્લે 6 માસથી કોઈ વાતચીત કરતો નથી. આ એનું વર્તન છે. અને ત્યારબાદ આ 27 તારીખે એના ફાધરે આ કમાડ તોડ્યા છે, પારણા તોડી નાખ્યા છે. અને ત્યારબાદ તારીખ ઘરમાં પ્રવેશ કરેલો તે વખતે મારો દીકરો તેના રૂમમાં હતો. બાદમાં મારા પતિ મને ફોન કર્યો, મિસ્ત્રી બોલાવેલ અને બહારનું તોડાવે. ત્યારબાદ આશરે 7:30 વાગે મારા દીકરી મારા પતિ માટે જમવાનું લઈ વૈભવ ટાવર ખાતે આવેલ અને આશરે 10:30 વાગ્યા સુધી રહે અને મારા પતિ જમીને રૂમમાં સુવા માટે ગયેલા અને હું તથા મારી દીકરી શીતલ એપાર્ટમેન્ટ ખાતેના મકાન ખાતે જવા નીકળી ગઈ અને અમે ઘરે ગયા પછી જમીને આશરે 10:30 વાગે મારા પતિને ફોન કરે અને સુવા માટે વાત કરી નથી. બાદમાં હું સુઈ ગઈ. હવે આ લાસ્ટ સીન ટુગેધર આ કમાન્ડ તોડ્યું પછી આ એના ફાધર છે એ બીજા રૂમમાં જ રોકાયેલા હતા. દીકરો એક રૂમમાં હતો અને આ બીજા રૂમમાં હતા. ત્યારબાદ આને લાસ્ટિંગ ટુગેધર છેલ્લે સુધી આ મા દીકરીને વાત થયેલી છે. ત્યારબાદ શું બન્યું સાહેબ? ત્યારબાદ આજરોજ 28/25 ના રોજ સવારે જાગેલ અને રાબેતા મુજબ ઘરનું કામ કરેલું, જમવાનું બનાવે. મારા પતિની 12 વાગ્યા સુધી રાહ જોઈ પરંતુ જમવા માટે આવેલા નહીં. તેથી મારા ફોનથી તેમને ફોન કરેલ છતાં ફોન ઉપાડે નહીં. બાદ મારી દીકરીએ તેના ફોનથી અવારનવાર મારા પતિને ફોન કરવા છતાં ફોન ઉપાડે નહીં. જેથી હું એકદમ ગભરાઈ ગઈ. આવું કોઈ દિવસ મારા પતિ કરતા ના હોય તેથી મારું એક્ટિવા લઈ આશરે બપોરના 1:30 વાગે વૈભવ ટાવર ખાતે આવેલ અને લીફ્ટ વડે ઉપર આવેલ અને મકાનનો દરવાજાનું લોક અગાઉ તોડેલ હોય, દરવાજો ખુલ્લી હાલતમાં હોય, મકાનમાં પ્રવેશતા બેઠક હોલમાં લોહીના ડાઘા પડેલ જણાય, જેથી એકદમ ગભરાઈ ગઈ અને મારા પતિના રૂમમાં જોયેલ તો મારા પતિ લોહી લોણ હાલતમાં બેડની બાજુમાં રૂમમાં ભોંયતળિયા ઉપર પડેલા હતા. ગરદનની ઉપર કોઈ ધારદાર હથિયાર વડે ઘા મારેલાનું જણાઈ આવે. બેડની ચાદર લોહીલુહાણ હાલતમાં હતી. ભોંયતળિયા ઉપર પણ લોહી પડેલું હતું, જેથી હું ગભરાઈ ગઈ. મારી દીકરી રવિના ફોન કરે અને મારી બહેનના દીકરા મનીષને ફોન કરી સદર મકાન ખાતે આવવા જણાવ્યું અને મારા દીકરાની રૂમ ખુલ્લી હાલતમાં હોય, જેમાં જોતા મારો દીકરો જણાઈ આવેલ નહીં અને તેની રૂમમાં પણ લોહીના ડાઘા પડેલાનું જણાઈ આવે અને તેની બેડની બાજુમાં કાળા હાથા ધરાવતું ચપ્પુ પડેલ હતું અને તે દરમિયાન મારી દીકરી રુચિ તથા મારો બહેનનો દીકરો મનીષભાઈ 108 એમ્બ્યુલન્સમાં ફોન કરીને બાજુમાં પોલીસ કંટ્રોલમાં ફોન કર્યો અને 108 એમ્બ્યુલન્સ આવતા મારા પુત્રીને ચેક કરતા મરણ ગયેલો. મારો દીકરો હાજર મળી આવેલ ન હોય. મારો દીકરો તેને મારીને નાસી ગયો છે. હવે રાત્રિના 10:30 સુધી આ બંને સાથે વાતચીત થઈ છે અને ત્યાર પછી આ બનાવ બનેલો છે. હવે ત્યારબાદ આગળ જોઈએ સાહેબ તો આ દીકરો છે સીસીટીવી ફૂટેજમાં 1:36 વાગે સાહેબ સીસીટીવી ફૂટેજ મેળવ્યા છે અને 1:36 વાગે સામાન સાથે જતા દેખાયેલો છે, ભાગી ગયો અને 1 તારીખે એની ધરપકડ થઈ છે. જગ્યા ઉપરથી એનો બ્લડ વાળો ચટ્ટો મળેલો છે. એ જ રૂમમાંથી આજે ચપ્પુ મળી આવ્યું, એ જ રૂમમાંથી ચટ્ટો મળી આવ્યો છે, બેડશીટ મળી આવી છે અને એને સાહેબ ધરપકડ કરી ત્યારે સાહેબ એની આંગળીઓ ઉપર ઈજા થયેલી છે. જમણા હાથની વચ્ચેની આંગળી અને ડાબા હાથની ટચની આંગળીની બાજુની આંગળી ઉપર ઈજા થયેલી છે અને ડોક્ટરે એવો અભિપ્રાય આપ્યો છે કે સાહેબ 28 તારીખે બનાવ બન્યો છે અને 1 તારીખે એની ધરપકડ કરી. ડોક્ટરે એવો અભિપ્રાય આપ્યો છે કે આ ઈજા 5 દિવસ પહેલાની આસપાસની છે, 5 દિવસની આસપાસની છે, એવી ડોક્ટરનો અભિપ્રાય છે. હવે બીજું સાહેબ કે આ છે ત્યારબાદ એના જે ચેટ છે સાહેબ જોઈએ, એના ચેટ પણ મેળવેલા છે. તેની બેનને મોકલેલા ચેટ છે, એમાં એને બધું જ સાહેબ ચેટ કરેલા છે. એમાં લખેલું છે કે सॉरी मैं सॉरी बोलता हूँ, मुझसे बहुत बड़ी गलती हुई, मैं क्या करूँ, लाइफ में मुझे कुछ समझ में नहीं आया तो मुझे जेल में बंद कर देना, मुझे मार देना, मेरा गला काट देना. એવા બધા મેસેજ એને કરેલા છે અને બધાને ગાળો બોલી છે. એના ચેટ પણ આ પેપર્સમાં છે સાહેબ, એવું નથી કરું છું મોબાઈલ ચેટિંગ અને એ એપ્લિકેશનમાં મોકલ્યા છે અમે. હવે હાલના તબક્કે એ લોકો છે સમાધાન કરવાની વાત કરે છે, પણ સાહેબ હાલના તબક્કે આ મેટર સિરિયસ છે અને એમને પોતે જ ફરિયાદીએ આ કેસ છે એ અતિ સિરિયસ છે અને એની દીકરીના એંગેજમેન્ટ તૂટી જાય એમ છે, એટલે આને સેન્સિટિવ કેસ ગણી અને મૂકવો. પોલીસે એવી આજીજી કરેલી અમે અને અતિ સેન્સિટિવ ફરિયાદ ગણેલી છે અને હાલના તબક્કે પછી પોલીસને ઉપયોગ કરી પછી આવે સમાધાન એવી રીતે કેવી રીતે ચાલે છે. એટલે હાલના તબક્કે આ વિચારી ના શકાય સાહેબ અને આરોપીના બધા જ એવિડન્સ છે અને એપ્લિકેશનમાં મોકલેલા છે એટલે હાલના તબક્કે આરોપીને જામીન ઉપર છોડવા માટે સખતમાં સખત વાંધો છે.
he was surrendered himself. પોતે જાતે હાજર થઈ ગયા. કોર્પોરેટ લેવા કીધા પૂછે તે જાતે હાજર થયા. અને ફરિયાદી અને એની ડોટર એ જુદા રહે છે અને આરોપી અને એમના ફાધર એ જુદા રહે છે.
બનાવ બન્યો ને પછી થાઈલેન્ડ ભાગી ગયો છે. થાઈલેન્ડ થી પછી પરત આવ્યો એટલે આવ્યો છે. ફરિયાદીએ ફોન કરીને આપણને બોલાયા હતા. એ જાતે એરેસ્ટ નથી થયો, તે જાતે સરેન્ડર નથી થયો. ફરિયાદીએ બોલાયા છે, થાઈલેન્ડ થી પરત આવ્યો ને.
You have got the complaint. You yourself filed the complaint, and now you are saying, no, we don't know anything. Your husband and your father has been accused is your brother and son. This is the result. Then why did you lodge the FIR? Why did you lodge the FIR?
પોલીસ આવી ગઈ. ત્યાં પોલીસ આવી ગઈ હતી. અમે 100 નંબર કર્યો.
No, you don't. તમારે explain નથી કરવું. તમે investigating officer છો.
tragedy અત્યારે એવી છે. Out of the
Tragedy is that your father has passed.
Yes.
That is the real tragedy.
હકીકત બહુ ખરાબ છે કે છે. હવે કેવું છે કે ફાધર ગુજરી ગયા, છોકરો જેલમાં, ફરિયાદી મધર, સાક્ષીમાં સિસ્ટર, ઘરમાં બીજો કોઈ છે નહીં.
Even he was staying outside. He was not staying jointly.
હા, બંને ફાધર અને છોકરા જુદા રહેતા હતા, મા અને દીકરી જુદા રહેતા, ફરિયાદી અને એની ડોટર જુદા રહેતા હતા, અને જે ડીસી અને આરોપી બંને જુદા રહેતા.
They have mistakes.
My discussion maybe using floor of the
Scale. Even on settlement, I am not inclined in this case. Since it is initial stage, it is not. Since it is initial stage, it is not proper to say something. They would have collected the evidence. No stranger has come there, and he has left. And that is seen in the CCTV and by hiring that auto or Ola, Uber, whatever.
સર સીસીટીવી માં જે ટાઈમ આપે છે એમાં લગભગ 4 થી 5 કલાકનું ગેપ છે. સીસીટીવી માં જે ટાઈમ આપે છે સીસીટીવી કેમેરામાં એમાં
Ultimate fact is then he should have not left. And there are checks. This case, if your affidavit, that will not.
પછી આ લોકોએ બોલાય અને પોલીસ પ્રસારણ કરતો છે. અને પછી ફરિયાદી લોકોએ પછી છોકરાને બોલાવે અને પોલીસ પ્રસારણ કરતા.
Order.
There are only 9 injuries, which is also been stated superficially, that injuries are simple in nature, and there is no fracture. All injuries are contusion and abrasion. Some injuries on the head and other parts of the body. But it appears that from the VM report that the dead occurred due to injuries sustained on head. Due to the injuries on head, the deceased succumbed to death. One more glaring aspect is that till date 9% have been arrested and 3 have been shown as an absconding. Whereas the allegation regarding that how many, what was the estimate of the mob which was chased down the deceased is not there in the entire charge sheet. only this 13% have been identified. Though there is an allegation there was a huge mob which were chasing the disease and given the injuries to them. But there is no explanation regarding the mob. Now only this person have been identified from it is alleged that they have been identified from the CCTV footage in which some of the person were chasing the disease who was driving rash and negligent in the Ertiga car which was in his possession. There is the allegation that they were identified from the CCTV footage of the chase. Now, one there are two FIR also been registered against the disease also. That I have also annexed. One came to be registered on 17th April 2025 for driving rash and negligent. So it is the case of Kurikulam also that the disease was driving rash and negligently have caused injuries to the general public and have also damaged the property of public. And that's why he was being chased by the public and ultimately he succumbed to death. One more FIR came to be registered and that is on July 7th, July 2025. So recently in this month only that FIR came to be registered. That FIR is of prohibition. That also I have annexed. It came to be registered against the disease. Now in that FIR it is stated that
Others are rejected. Other two accused I have rejected recently.
I understood. Yes, yes. Yes, sir. Yes, sir. Yes, I'm aware. I'm aware.
But none of these granted by High Court. Anyone is granted.
No, they have not been to High Court yet.
They have not.
No, nobody has been.
તે કરે ને એમ કદે પીએમ માં આવી ગઈ
The visa reject thing is that this court has power under good seater because it is very specific only in section 20. When you have read the judgments in deep, you would be aware of their provisions. I believe that.
But still the brother is protected by the High Court in 438 procedure. It is not 482 procedure. Now, why I point this out? That as far as organized crime is concerned, the purpose of reading this is that
First, if I have the power, then I can exercise. Then I can go to every argument which you are pointing
yes,
out.
I am addressing that. What I am addressing the court is that prima facie, if an offense does not exist, does it bar any court from exercising the powers in the 438? The answer is no. And I am drawing a corollary. These are special acts. As far as lucid office is concerned, I am drawing a corollary with the atrocity act.
Atrocity, yes.
And I have placed on record the case of Subhash Kashinath Mahadev. In that case, the court held that if prima facie, if an offense is not made out, then it will not bar the court from entering into this arena. It does not mean that simply because of the whims and caprice of a person, if an FIR is registered, the accused should be remediless. If prima facie it appears to be completely illegal, the court definitely has powers. Now, in the incident case, the two offences are of 16/4/2020 after the registration, after the promulgation of the Act. What is the offence made of? The first offence was the discharge is filed. That the two brothers were breaking the COVID violation. They were brought to the police station. The father came to the police station to get them released. When the father came, there was a scuffle with the police officers. And thereafter, the second FIR came to be filed. Both are of the same day. Now, as far as the first is concerned of COVID violation, the discharge is already filed. The discharge comes to be filed on 10/7/2021. I have placed everything on paper. Still subsequently, a month after that,
that is on 27/8/2021, the FIR in question is filed. When this particular offence is incorporated as a ground for filing the FIR, though it cannot be, the person filing the FIR is very much aware that the offence which is showing as the basis for filing the FIR a month prior, discharge is already filed in that case. So that leaves only the second FIR. What is the second FIR? That the father has come to get them released and there is a scuffle. Now, as far as this incident is concerned, which is said to be when the two brothers are supposed to be violating the COVID violation, the father is brought. I have placed everything on record. The mother of the petitioner has made not one, but repeated representations to the authorities concerned that these people, the concerned police station, they literally came to our house, ransacked our house, picked up people from our house and took them to the police station. It is not that it was a case of COVID violation. For that, she makes a request for the CCTV footage. Kindly just see these two documents. The application for the CCTV footage. The board will find it at page 66. Okay.
Whatever.
Address to the DSP Barton. Babat Simple Police Station Guna register, that is the second FIR of the same day. કામે તારીખ so and so સુધી પોલીસ સ્ટેશનનું સીસીટીવી ફૂટેજ લેવા બાબત અમો અરજદાર તરફે ફરજ કે અમો અરજદારના દીકરાઓ તથા પતિ પર સિદ્ધપુર પોલીસ બધાવત રાખી સિદ્ધપુર પોલીસ સ્ટેશન ગુના રજિસ્ટર so and so ફોટો દાખલ કરી અને બંને દીકરાઓએ one of them is the petitioner હાલમાં ધરપકડ કરેલ છે સદર કહેવાનો ગુનો બનાવવા વખતે અમો અરજદારના બંને દીકરાઓ સિદ્ધપુર પોલીસ સ્ટેશન ગુના રજિસ્ટર that is the first where the discharge is filed 227 ના ગામે સિદ્ધપુર પોલીસે અટક કરેલ હતા અને તે વખતે અમારા બંને દીકરાઓ સિદ્ધપુર પોલીસની કસ્ટડીમાં હોવા છતાં અમો અરજદારના બંને દીકરાઓને સિદ્ધપુર પોલીસ સ્ટેશન ગુના રજિસ્ટર સોળના ગામે ખોટી રીતે અટક કરેલ છે સદર બનાવ અંગે તારીખ 16/4 ના રોજથી પોલીસ સ્ટેશનના સીસીટીવી ફૂટેજ લેવામાં આવે તો સદર બનાવની બાબતની સાચી કરી હકીકત આપ સાહેબને જાણ આપવામાં આવે છે આપ સાહેબને વિનંતી છે કે તારીખ 16/4 so and so સુધીના સિદ્ધપુર પોલીસ સ્ટેશનના સીસીટીવી ફૂટેજ લઈ સદરુ વિલેજ સિદ્ધપુર પોલીસ સ્ટેશનના ગુના રજિસ્ટર નંબર 16 ના કામે સામેલ રાખવા મારી વિનંતી છે સદર સીસીટીવી ફૂટેજ અંગે જે કંઈ ખર્ચ થાય તે અમે ભોગવવા તૈયાર છે that you put it on record with the concerned FIR which I am saying is fabricated, concocted against me, and I am willing to pay the cost for that. Now the court may kindly see what reply she is getting to this application. Well, the court will find it on page 71. આથી તમને જણાવેલું the police inspector LCP Barton is informing the mother of the petitioner. આથી તમને જણાવવાનું છે કે તમારે સિદ્ધપુર પોલીસ સ્ટેશન ગુના રજિસ્ટર સોળના કામે તારીખ 16 સુધીના પોલીસ સ્ટેશનના સીસીટીવી ફૂટેજ લઈ ગુનાની તપાસના કામે સામેલ રાખવા બાબતને અરજી પોલીસ અધિકારી શ્રી વિદેશ મોકલેલ છે જે અરજીમાં ક્રમાંક 16 થી નોંધ થઈ ઉપરોક્ત ગુનાનો તપાસ અમો કરતા હોય અરજીની તપાસ અમને મળતા આપણે આપની અરજી કરેલ રજૂઆત બાબતે અમને સિદ્ધપુર પોલીસ સ્ટેશનમાં લગાવેલ સીસીટીવી કેમેરાનું ફૂટેજ મેળવવા સારું સોળના રોજ માહિતી માંગે છે પરંતુ સિદ્ધપુર પીઆઈ શ્રી દ્વારા જણાવેલ કે સિદ્ધપુર પોલીસ સ્ટેશનમાં લગાવેલ કેમેરાનું UPS, તારીખ so and so ના રોજ બંધ થઈ ગયો. That is just 2 days before they were arrested. અને જે બાબતે ફરિયાદ નંબર so and so, તારીખ so and so ના રોજ નોંધાવેલી, પરંતુ તે ફરિયાદનો નિકાલ કરેલ ન હોય, જેના કારણે સુરત પોલીસ સ્ટેશનમાં લગાવેલ સીસીટીવી કેમેરા બંધ હતા. તેથી આ કામે સીસીટીવી ફૂટેજ મેળવી શકાય નથી. તેથી આપની અરજી તપાસના કામે સામે રાખી ફાઇલ કરવામાં આવે છે, તે બાબતે નોંધ કરશે. Now if the CCTV footage comes, everything will become clear. That how the second FIR came to be concocted, how the people, the entire family rather of the petitioner came to be dragged and brought to the police station. There are other applications also of the mother of the petitioner, which I have placed on record. She is literally crying for help, that please help us. These police are after us, not prosecuting us, but persecuting us.
Yes.
Now you are only going back to the question raised by the court, that whether the court can enter into this arena when there is a specific bar. The answer is yes. It can if prima facie the court sees that this offense cannot be invoked in the first case. Just and not and there are other special acts. This is also a special act. There are other special acts, NDPS, XYZ. I am drawing a corollary with the atrocity. Where I have placed on record the case of Subhash Kashinath Mahajan. In 2018, the Supreme Court drew a line that just because a person is made an accused, that does not mean a statutory limitation will prohibit the court from entertaining an application under 438 if it is satisfied that prima facie no offense exists. In this particular case, why I read the case, the decision of Kuchi Talk by the Supreme Court? Because the law is dissected by the Supreme Court. Here, the prima facie ingredients are specified. Kindly allow me to go back to page 18. On the left, the paragraph 10, the court has it.
Yes.
The very fact that more than one charge sheet has been filed against the respondents alleging offences punishable with more than 3 years is not enough. As rightly pointed out by the High Court, commission of offences prior to the enactment of MOPOCA does not by itself constitute an offence under MOPOCA. Registration of cases, filing of charge sheets, and taking of cognizance by the competent board in relation to the alleged offence, if you have been committed by the respondents in the past, is what's one of the requirements for invocation of section 3 of MOPOCA. Continuation of unlawful activities is the second and equally important requirement that ought to be satisfied. It is only if an organized crime is committed by the accused after the promulgation of the act, seen in the light of the previous charge sheets and the cognizance taken by the competent court, is said to have committed an offence under the act. An organized crime is committed by the accused after the promulgation of the act. Thereafter, in the case at hand, the offences with the respondents are alleged. So we may skip that. On the right hand side is subpara 8. By analyzing the expression continuing unlawful activity, the apex court has held that filing of more than one charge sheet for the offence punishable with more than 3 years imprisonment is not enough. Now, in the instant case, there is not more than one, there is only one charge sheet. But it must be satisfied that the continuation of unlawful activities is the second and equally important requirement that ought to be satisfied. It is only
Investigating officer simple thing is RTO to proceed.
It is only emphasis applied if an organized crime is committed by the accused after the promulgation of the act that has to be considered in the light of the previous charge sheet. Now the offence is questioned when the father comes to the police station to secure the release. This is the offence made out. We may say it that way. Still, whether it falls under the category of organized crime, I will read the definition of organized crime. This, thus, the contention raised by the learned advocate with regard to the prospective effect of the act is not palatable in view of the efforts and observations made by the apex court. But at the same time, it is noticed that in the present case, the expression continuing unlawful activity is not satisfied in view of the offences which are considered by the authority. We may skip that. Thereafter, if the court may turn to page 83 of the compilation. On the left, the last paragraph, the court will say an overview of the Iran Control of Terrorism and Organized Crime Act, 2015. The Woodstock, as a long time to suggest, is an act to make special provisions for the prevention of control of terrorist act and for coping with criminal activities by organized crime syndicates. So either there is a terrorist act or an organized crime, this special act can be invoked. Whether it can be invoked in each and every case, ordinary routine criminal case, the answer is no. And for the matters connected therewith or incidentally therein. The statement of objects and reasons contain the reasons which constitute the foundation for the legislature to step in. First, organized crime which is in existence for some years poses a serious threat to the society. Organized crime is not confined by national boundaries. Thirdly, organized crime is fueled by illegal wealth generated by contract killing, extortion, smuggling, contraband, illegal trade in narcotics, kidnapping for ransom, collection of protection money, and money laundering and other activities.
You can skip for this because we are dealing with day and day. The definitions, and I have gone through the judgment of Om Prakash Gupta also. But you can just point out how it would be maintainable
Yes,
before this course.
yes, very good.
Organized crime syndicate, continuing unlawful activity,
Very
they
good.
all have.
Very good. Just below, on the same page on the right hand side, the definition of organized crime is reproduced.
Yes.
What is the definition of organized crime? Organized crimes mean any continuing unlawful activity and terrorist act, including first is extortion, land grabbing, contract killing, economic offences, cyber crimes having severe consequences, running large-scale gambling rackets, women trafficking, racket for prostitution, or ransom by an individual, singly or jointly, either as a member of an organized crime syndicate or on behalf of such syndicate by use of violence or threat, or intimidation or coercion or unlawful means. Now, in which category this offence falls? The law is now very clear that after the promulgation of the Act, that is after 1/12/19, there has to be an offence of organized crime to invoke Puchitov. And before that, there have to be two charge sheets. Now, the first part fails because there is only one charge sheet. As far as the second part is concerned, after the promulgation, this is the definition of organized crime. By which stretch of imagination the offence in question, where the father has come to get the release, there is a scuffle in the police station, can be considered as an extortion, land grabbing, contract killing, economic offence, cyber crime, gambling, women trafficking, prostitution. The law is very clear, the definition is very clear. We may now just go to that particular FIR in question, which is after the promulgation of the Act. The court will find it at page 47. As I pointed out earlier, even for this particular FIR, the mother has been running helter-skelter. She has been requesting that kindly provide me the CCTV footage. My family is being framed in a false case. But even if we take the case as it is, the descriptive part, the court will find at page 48. In column 12, the court had આ કામો હકીકત એવી છે કે કામના બહુમતદારના દીકરાઓ લોકડાઉનમાં બહાર નીકળી જાહેરનામાનો ભંગ કરતા જેઓને પોલીસ સ્ટેશન તારીખ તેમના વિરુદ્ધ કાયદેસર કાર્યવાહી કરતા હતા તે વખતે બહુમતદાર નંબર 1 મયુદ્દીન અકબરિયા સૈયદ Irani Chapra, Silpur Wada, Silpur police station, Arizona, Mitra, Village police, kindness and Kazara, Kare, एक कार्य में विकास कई दारू मूली तथा पिता समुदाय पर थे रियाज में तथा समुदाय पर ऊपर में नाव में सिद्धू पुलिस स्टेशन की बड़ जल्दी की गई जवाब जता आ काम ना फरियादी है हमने रोकवा जता એટલા ઉપર સमुदाय ઉપર એક હુમલો કર્યો ગાળો મૂલી જાનથી મારી નાખવાની ધમકીઓ આપી ફરિયાદની દાબી આપી ઉપર બેટ મારી બીજાઓ કરી ફરિયાદીનું ગળું દબાવ્યું એ કરવાની કોશિશ કરે હોય તેનો સमुदाय ઉપર પ્રયત્ન ફરિયાદી સાથે ધપાધડી કરી ગુનો કરવામાં મદદગારી કરી સમાધાન ઉપર એક ઝાંસી દેવી તેમજ સમાધાન ઉપર બે સમાધાન ઉપર ત્રણ બંને જણા પકડાઈ ગઈ ગુનો કર્યા વિના. Now the court will see by which stretch of imagination this can be considered in the definition of organized crime, which is the law. Can it be said that this was an offense of organized crime committed after the promulgation of the act, which required the invocation of Lucino? As we read, these are the specific, it is a very specific definition. Land grabbing, extortion, prostitution, economic offenses, cybercrime, the definition is very clear. Now the court will kindly turn to the FIR in question. The FIR begins at page 30. The relevant portion the court will find at page 17. At the bottom of page 17, the offence is qualification. Now, Sayyid Akbar Mia, son of Mayuthi, Madam Silpur regarding Chapra. Kindly turn to the next page, page 18. The list of three offences. The first offence is of 2016. The offence under 504, 506, part 2. So far, so good. But this is the only offence. So the law stipulates that there has to be at least more than one charge sheet. Now, this is before the promulgation, before 2019. After the promulgation, the second one, which is 227 of 2020. This is for the lockdown violation. Now, the question is that how this is made the basis for invocation of Butsitok. Because when the charge sheet is filed in the 8th month, the discharge has already taken place in the 7th month. In this particular FIR, is it not a concealment on the part of the IO, or rather an offence in itself, where he forms the basis of filing the Butsitok FIR, very well knowing that this discharge has already taken place. It nowhere mentions anywhere that discharge has taken place. Thereafter, both are of the same day, 16/4/2020. The first supposed to be a COVID lockdown violation, when both the brothers are born. Even this, by any stretch of imagination, cannot be considered an organized crime. And the second of the same day, 2/28 of 2020, the MI which we just read, completely personal in nature. And thereafter, in the bottom, the note, the court will see that આમ ઉપરોક્ત આરોપી વિરુદ્ધ Butsitok Act ની કલમ 21C મુજબ છેલ્લા 10 વર્ષમાં કુલ 3 ગુનાઓ દાખલ થયેલ છે અને કુલ 3 ગુનામાં ચાર્જશીટ કરવામાં આવે છે. Here also there is no mention that discharge is taken place. The Butsitok Act ની કલમ મુજબ continuing all the unlawful activities સતત ચાલુ રાખેલી છે. They will take it that it is done out of ignorance or out of intention. Even here, it's tried to impress upon that this is the basis for filing the FIR. Where is the mention that discharge has already taken place over here? Now, drawing a corollary with the power of the court to exercise the power to enlarge on anticipatory, whether it can be curtailed just because the statute says so. That is, the Supreme Court says no. Supreme Court very categorically says that if prima facie an offence is not made out, the courts very much have the powers. And the statute cannot take the powers from the court in any fashion. I will just read the relevant portion on page 99.
Yes.
That's page 99. I will just go in the reverse order. First, take the court to the conclusion arrived at in this division. The court will find it on page 139.
Yes.
Paragraph 83 is the conclusion. Our conclusions are as follows. Proceedings in the present case are clear evidence of the process of court quashed. There is no absolute bar against the grant of anticipated cases under the atrocity. If no prima facie case is made out, or where on judicial scrutiny the complaint is found to be prima facie nullified. So if no prima facie case and on judicial scrutiny prima facie the complaint is found to be nullified. We approve the view taken and approach of the Gujarat High Court in Pankaj Sudhar and NT Desai to clarify the judgments of this court in Palotia and Convenience. Thereafter, the 3 and 4 came to be diluted the next year in the case of Union of India versus State of Maharashtra, where conclusion 3 and 4 were removed. Subsequently, even by the provision, the Parliament enacted Section 18A in addition to 18. Even that came in question in the case of Prithviraj Chauhan. I just introduced all this decision in the memo of my application. And in Prithviraj Chauhan also the court said that now 18A, the question would be elementary in nature because ultimately these 3 and 4 have been struck down. But even in Prithviraj Chauhan, the court came to the conclusion that yes, the power of anticipatory cannot be taken away from the court if prima facie the case does not exist, and if the court prima facie sees that this is a mala fide. Now, I will just go in the reverse order. How the court came to this conclusion? Kindly turn to page 127.
Yes.
Paragraph 48. The issue of anticipatory bail. In the light of the above, we first consider the question whether there is an absolute bar to the grant of anticipatory bail, in which case the contention for revisiting the validity of the said provision may need consideration in light of the decision of this court relied upon by the learned amicus. Section 18 of the Act contains the bar against grant of anticipatory bail. It is as follows. The section is including in Palotia. Thereafter, we will straight away go to 51. Though we find merit in the submission of the learned amicus, the judgment of this court in Palotia may need to be revisited. In view of Palotia ultimately came to be overturned. May need to be revisited in the view of the judgments of this court, particularly Mehta Gandhi. We consider it unnecessary to refer the matter to the larger bench, and the judgment can be clarified in the light of the law laid down by this court. Exclusion of anticipatory has been justified only to protect victims of perpetrators of crime. It cannot be read as being applicable to those who are falsely implicated for extraneous reasons and have not committed the offence of prima facie independent scrutiny. Access to justice being a fundamental right, brain has to be separated from the shaft by an independent mechanism. Liberty of one citizen cannot be placed at the whim of another. Law has to protect the innocent and punish the guilty. Thus considered, exclusion has to be applied to genuine cases and not to false cases. This will help in achieving the object of the law. Thereafter, the court may straight away go to paragraph 56, page 1 to 9.
I think you should read paragraph 52 also of this judgment. Paragraph 52.
I read.
Yes, you please go through that.
Yes. Shall I read?
Yes, you read.
If the provisions of the Act are combined against certain other enactments, where similar restrictions are put on consideration of matter for anticipatory, an interesting situation emerges. Section 17(4) of the Tata Article. Nothing in section 438 shall apply in relation to cases involving the arrest of a person. Section 17(5) of the Tata put further restriction on a person accused of an offence punishable under Tata being released on regular bail. And one of the conditions was that the public prosecutor opposes the application for grant of bail. The court had to be satisfied and whether reasonable grounds for believing that the accused was not guilty of such offence and that he was not likely to commit any such offence while on bail. So first court need to be satisfied and completely opposed that he was not guilty of the offence and that he would not commit any such offence while on bail. The provision of Tata, namely under Section was similar to the aforesaid section of Tata. Similarly, the provisions of Makoka are also identical in terms. Thus, the impact of release of a person accused of having committed the offences under the enactments was dealt with by the legislature, not only at the stage of consideration of the matter for anticipation, but even after the arrest at the stage of grant of regular bail. So, these are also the special acts. In some cases, the special acts have this provision that even for regular bail, they will not be able to.
So that was the, you can read further.
Yes, the provision of the NDPS, however, distinct in that the restriction of the 37 is at the stage where the matter is considered for grant of regular bail. No restriction is sought and put in place at the stage of consideration of matter of anticipation. On the other hand, the provisions of the Act are diametrically opposite, and restriction in 18 is only at the stage of consideration of matter for anticipatory bail. And no such restriction is available while the matter is to be considered for grant of regular bail. Theoretically, it is clear, it's possible to say that an application under 438 can be rejected because of express restrictions in 18. But the very same court can grant bail under the provisions of 437 immediately after the release. There seems to be no logic rationale behind the situation of putting a factor of grant of anticipatory where there is no such prohibition in any way of a grant of regular. It is therefore all the more necessary and important that the express exclusion under 18 of the Act is related to genuine cases and inapplicable where no prima facie case is made. So again, this also the court comes to the conclusion.
Court comes to the conclusion on the basis that if the offences under Atrocity Act, it can be considered under section 437 because there are no other restrictions like other special statutes like TADA, MAPOCA or NDPS.
And also under 437.
You are not under 437 because there are further restrictions in the good seat of offence. The very same twin condition which are found, which are having place in TADA and MAPOCA Act, and MAPOCA is almost very material to this good seat of as the very same twin condition, coupled with the fact that the punishment prescribed in this act are more stringent, with minimum punishment extending up to life.
And not taking a statement, but continuing in Subhash Kashinath Mahajan.
See, this was the logic. This was the logic which was applied by the Supreme Court in that while considering the anticipatory bail application, and therefore, coupled with the twin condition.
Is coming back to what I was saying, that in 2018, the Supreme Court set a precedent that if there is no prima facie case and if the complaint appears to be nullified, then the statute will not put fetters on the court from exercising the powers under 437.
Even if we go
Anticipatory.
even if we consider, first of all, I am not so far as 438 is concerned, I have not found any decision on the very same statute under good seat of. Secondly, if I go by your argument also, that there are no two offences more than one charge sheet. Now the present FIR is filed in the year 21.
Good seat of
Good seat of 21. Then arithmetically, one FIR is of 2020 and one is prior to 2019. Good seat of Act, it says that preceding 10 years there should be more than one offence.
That is why I was reading the Supreme Court decision. Where the Supreme Court has dissected that there have to be two FIRs
That
before the promulgation and one FIR of an organized crime. Just allow me to read it, I will satisfy the court.
then you read last paragraph of Sandeep Om Prakash Gupta also, where it is stated that the prosecution has not to wait, let him commit one more other offense.
That is for two offenses after the promulgation. That is what the court is saying. I will just read, I will
The
satisfy.
subset of offense, it says, it nowhere says, no doubt, Sandeep Om Prakash Gupta has clarified some positions. So there should be at least one offense that should have been committed after promulgation of this good set of offense. To consider it to be a continuing unlawful activities. Your content says there is only one offense prior to 2019. One is pertaining to 188. So for which your discharge has been filed. Now after promulgation of offense, there is one offense, that is 2020 offense. So first you are contending that there is no two offense prior to 2019. Neither there are two offenses after 2000.
No. I'm not being able to convey. What I'm saying is that after the promulgation, two offenses are not, that is not.
There is one offense,
One
but prior
offense
to
is
that,
sufficient.
okay, I take it.
But it
Prior to
should be of
2019, prior to 2019, there is only one offense.
Yes.
And other offenses 188, they cannot be considered as an organized crime.
Then
Yes.
even if we omit that, what my contention is that is one offense after the promulgation has to be an offense of organized crime to invoke good stop.
Yes,
It
you are right.
cannot be an ordinary offense. Or what will happen is that in police we have the discretion to invoke Dukshi talk in each and every case that they like. These are special acts for special people for special offenses. What is happening here is that it has been used in routine offenses. These are not this is not a special
That,
offense.
we would not go, since this being a special court, your argument would be before the constitutional court. So far as the virus are concerned, that are already upheld by the High Court at least.
Here,
I will
And,
already filed caution for this.
and
Yes, I
even-
placed it on record, that is a new.
And even the provision of Mapoka were, which are very material, that were challenged before the Supreme Court. And in Virajpur judgment, which he would be relying, Mapoka provision are upheld. And even in this case also, by applying the principles which you are relying, I would say that there are certain other statutes where it is held by the Supreme Court that they are having sufficient checks to prevent the misuse. So that arguments now, I don't think even it is whether it is PMLA case, whether it is Rutsito, or whether it is Mapoka, or another special statute which are having stringent provisions, and where there are arguments are raised that these are being misused, anyone can look at anyone. So all those provisions are upheld by the Supreme Court also.
So we just satisfy the court on these two counts. That one, as the Supreme Court says, how did it set the precedent in 2018? Set the precedent in two categories. That once, prima facie no case, and two, when
See-
an apparently magnified complaint.
See there, in this case, Subha's case, the logic was applied rightly. This is the law, okay, now under atrocity, the bar would not apply. If a case is made out, it does not even whisper about a single word or even alphabet, then court can exercise.
There is another recent decision of the same, of very recent, just few months back. And point out that also later on. Where this view is.
Okay, if you point out, then I am ready to consider under good Sito. I could not lay down. Under 430, I could not find out. Otherwise, I would even he would be Mr. Limbachia would be appearing for the prosecution, but he would be having this thing in your mind which you are contending. Yes, there are some stringent provisions. But ultimately, I being a special court, I would have that restrictions.
Yeah, ultimately, just to put it in a couple of lines, that if the court is satisfied that prima facie offense is not made out and the complaint is indeed bona fide, there is nothing which can prevent this court from setting a precedent by saying that yes, as per the corollary, as per the parallel drawn with the case of Subhash Kashinath Mahajan and subsequently upheld from the line of Supreme Court from time to time. Here also, prima facie, there is no case, and this court can exercise 428.
You're absolutely right. Now this would be the author of Sandeep Om Prakash Gupta's judgment has also authored a judgment under GPIDA. while his lordship was at the Gujarat High Court, where very same provision under that section 438 applicability was raised. It was said, it would not lie because the special court can't exercise. This judgment were relied of the atrocity. Yes, sir, if it is found, then it can rely.
So, again, one
So under
factor,
GPID Act, it was held no. Constitutional courts, they can exercise irrespective of bar under section 438.
the one factor which may perhaps assist this court, that it is not setting a precedent, but there is a precedent, and the court is only following a precedent. The court will find it at page 50. So that's this is the order of the High Court. These are also proceedings for anticipatory
Yes,
case.
yes. But it is High Court.
The court can see the protection is granted.
Yes, yes.
So the court is not going to set a precedent.
No, I'm not selling. No.
And this is the
High
brother
Court-
of the petitioner. They co-accused in the case, same FIR. Now, if in the same FIR, the one of the accused, his case has been considered as an exception. There is no reason why this court cannot follow this precedent and consider the case of the applicant.
Repeat, whether it is to be treated as a precedent or not, that would be one more question. Whether this oral order would be considered as a precedent, that would be another question.
Why not treat it as a precedent?
But how can I?
Same FIR,
You are right, absolutely right.
co-accused.
Then every bail order would be binding to, if every oral orders are to be considered as a precedent. See, there are difference between oral orders and precedents. Precedent settles a law. Just like you are relying upon Mahajan's case, that is a precedent that is binding to every court. Had there been a case under Gutsilok, I would certainly go through your own.
This order is of which of the particular same FIR, the co-accused, the court on the ground of parity as well as precedent, it can be
And
considered.
even if I go by Mahajan's case, then also that paragraph which I asked you to read, paragraph 52, that would clearly,
Ultimately, what I was reading, it refers to the context of the conclusion.
you are right, in atrocity case, even after the Supreme Court said anticipatory bail no restriction, that is ultra vires, again it was brought in the statute. Again, it was challenged. Again, there are judgment yes, anticipatory bail would lie by the Supreme Court also and by our High Court also. Yes, it is maintainable. Even after the new amendment. And courts are considering also, but there is very specific orders, judgments. Yes, you can entertain. So far as this case is concerned, there are twin conditions even while deciding the regular bail applications. And the court will have to form a satisfaction that he is not guilty of an offence and he shall not repeat that offence. And this all aspects are considered while considering Mahajan's case.
In this case, the order of the co-accused, all these factors have been considered and yes, and his application for anticipatory is considered.
It is only for coercive steps shall not be taken.
This is as far as the anticipated bail application. So if the court is looking for a precedent or on parity, it could pass the order on this basis.
See, either there can be two things in a lighter way. I would be having same power as that court was having, which I am not having right now. Or I would be having same decision, just like you are having in atrocity case, similar decision or case law on good sit, okay, then I would certainly, I would be happy for deciding that.
But ultimately the court would be satisfied. And prima facie, these people have unnecessarily been roped in this particular offense.
That jurisdiction is with the posting court or at the time of discharge.
But what should it be that just because there is a statutory limitation, they should be remediless? They should,
No, they are having remedy. They are not. Your brother is already aware that remedy. So they are not remediless. Anyway, anyone is remediless, then the remedy lies there. But since this is Gutsito, had it been atrocity, then I would have certainly considered without any hesitation or putting even a question to you how it would be maintainable.
The brother is also given the remedy in the same good situation.
But by which court?
But now that the higher court has said the precedent, what I submitting that this court could adopt this.
But then I should know, okay, yes, I am having that powers of 438 also while sitting as a.
They just read that. I just read 2 paragraphs of Sandeep Gupta. Only 2 paragraphs, how the Supreme Court has dissected. Since the law is very recent, we have very few decisions. But in this particular decision, very clearly, the Supreme Court has dissected.
This judgment is the judgment of Sandeep Omprakash Gupta is certainly taking care of the apprehension of the accused. If there are genuine apprehension, it take care. But other judgments of Mokoka are concerned that they do not. They say no. These are all the provisions are obtained.
But the reason is that the Makoka came into existence in 1990. The Lucidov came into 2019. So apparently a law which came into force 20 years back got much developed in the courts of law. A law enacted by the parliament came to be dissected from time to time by the courts of law. And therefore, if this is a very nascent law, while deciding the case of Sandeep Omprakash Gupta, the court has made it as a base or
Yes, sir, it is. Otherwise, it was an
deciding
order granting bail which was challenged.
Yes.
There was no necessity to go into the some validity or interpretation of the sections. But court has gone because to see that there are no misuses. That's the
only the court may turn to page 96. Paragraph 50 on the right hand bottom. There is a vast difference between the act of activity, which is being termed or called as an offense under a statute, and such act or activity being taken into consideration as one of the requisites for taking action under the statute. For the purpose of organized crime, there has to be a continuing unlawful activity. There cannot be continuing unlawful activity unless at least 2 charge sheets are found to have been lodged in relation to the offense punishable with 3 years imprisonment during the period of 10 years. Now, the court may kindly see this line. Indisputably, the period of 10 years may relate to the period prior to 1/12/19 or thereafter. So, this period of 10 years, 2 charge sheets has to be before the promulgation of that. In other words, it provides that the activities which were offenses under the
no,
law
it can't be.
enforced-
See, you read that indisputably the period of 10 years may relate to the period prior to 1/12/2019 or thereafter.
No, it is being clarified, the court clarifies below. In other words, it provides that the activities which are offensive under law enforced at the relevant time and in respect law enforced at the relevant time, that is before good law, and in respect of which 2 charge sheets have been filed and the court has taken cognizance thereof during the period of preceding 10 years, then it will be considered as continuing unlawful activity on 1/12/19. It is clarifying. So till 1/12/19, there has to be 2 FIRs where charge sheets are filed, and then it is punishable with more than 3 years. It November itself declares an activity to be an offense under the Act prior to 1/12/19. It also does not convert any activity done prior to 1/12/19 to be an offense under the said 2015 Act. It merely considers 2 charge sheets in relation to the acts which are already declared as offences under the law in force. That is, before Lucidov came into force, it is one of the requisites for the purpose of identifying continuing unlawful activity and for the purpose of an action under the 2015 Act. Now, just one more page, on page 83.
Even if I have read it number of times to understand the because I was also to understand the law. But you may also go through it. the Gutsitoke Act, it does not say for anything about one offense or two offense or three offenses. If we go by the definitions, the Gutsitoke has never said okay, one offense or two offenses. Now, when this matter went to the Supreme Court, there was another judgment, Sonwade,
Yes, yes.
Sonwade,
That is of
Shivaji
Makoka.
Sonwade.
That is of Makoka.
Makoka. There's something took place, so there should be more than one charge sheet. So far as if we go by the definition of Gutsitoke, it does not say one or two offense, more than one offense, which has only merely defined. If this is found, then yes.
No, the definition says more than one charge sheet.
Where?
Yes,
Yes,
that is what the definition says.
Definition of
Yes.
Gutsitoke definition.
Section two.
It is section 2(1)(c), continuing unlawful activity. On the next page, on page 84, it is there. I was just actually reading that only. On page 84, on the top left, small c, continuing unlawful activity, section 2(1)(c). Continuing unlawful activity means an activity prohibited by law for the time being in force, which is a cognizable offense. Punishable. Again, for the law for the time being in force, which is a cognizable offense, punishable with imprisonment for a term of 3 years or more, undertaken either singly or jointly as a member of the organized crime syndicate or on behalf of such syndicate in respect of which more than one charge sheet 75. So it could be 2, 3, 4, 5, but not one. Before a competent court within the preceding period of 10 years, and that court has taken cognizance of such offense. Now, this preceding period is expounded in Sandeep Gupta. And the Supreme Court says that it has to be the preceding period, preceding 1/12/19, for the offences for the which was for the law for the time being in force, before Gutsitoke came into effect. So, the definition very much says that more than one charge sheets, it is very categorical. But the term preceding 10 years is expounded by the Supreme Court in Sandeep Gupta.
Yes.
And even I basically read the definition of organized crime as well as continuing unlawful activity. The court is
Now, if you go by the definition of organized crime, in the new BNS, then what is not in the definition provided, Gutsitoke, that offenses are also covered. It has, I think, 111. 111 of BNS, it has defined organized crime.
but in this case,
No, in this case, is another thing.
but invoke an offense, it will have to be shown that this offense subsequent to the promulgation is an offense which falls under this category. The parliament would not have framed this statute. It could have just said any offense. But the intention of the parliament is that there are specific offences taking place for which a special act is required. Now, if the special act is required is to be invoked in specific offences, and the accused are pointing out that
As on date, we will be going by the offense which are provided in the Gutsitoke only. But the organized crime definition now has been included in BNS, even prohibition offenses. Anyway, now.
yes, there are some, you may say that most of the act is the same, but even if the court will see 304A. So earlier it was only 2 years. Now in the new act it becomes 5 years, and there is a specific category for rash driving, where it can exceed to 10 years if the driver runs away without reporting the incident. So I agree,
just kept on
with the
change.
concept that more or less it is the same, but there are some changes.
Some changes.
So again, the definition is very categorical, that it should be an act of extortion.
Okay, so as per
and-
your submission, the restrictions would not come in way and he may be granted anticipatory bail.
I would impress upon the court that to lay a foundation on the basis to draw a parallel or a corollary with the case of Subhash Kashinath Mahajan, where a precedent was set. And in this case also, that prima facie, there is no offense. In addition to that, we are pointing out that it is a malafide complaint, coupled with the fact that the co-accused in the same FIR is also given this protection, the same relief can be granted by this court.
I will record your own credentials. Yes.
I appreciate it. I'm grateful.
I will not take much time because the law is very much clear on this aspect. So far as the anticipatory bail, the receipt of this concern, there is a bar that has been mentioned in section 20 subsection 3 of receipt of health. And thereby the present application is not material. My learned friend has relied upon the oral order of the Honorable High Court passed in case of the brother of the present applicant, wherein the rule has been issued and the co-accused has been protected. The Honorable Court may kindly see that this order has been passed in the year of 2021. Thereafter, in one of the good seat of matters, where the anticipatory bill was passed, filed before this Honorable Court, and the Honorable Court has rejected that application, the matter travels before the Honorable High Court, and the Honorable High Court has observed something with regard to the application, anticipatory application, filed in such type of cases. This is order dated 13th of July 2022. The order has been passed in anticipatory bail. The accused was booked under good seat of it. Page number 3 is relevant. The Honorable Court had, after hearing all the parties, raising also this this submission of the APP, rejected the application. Page number 3, the Honorable Court would find. Having heard the learned advocate for the parties and having considered the documents and investigation paper on record, the following relevant aspects are considered by this court. 1. Having regard to section 20, subsection 3 of the Receipt of Act, it appears that the present application itself would not be maintainable, more particularly since the legislature has excluded application of section 438 of the Code of Criminal Procedure to any person accused of having committed an offence punishable under this act. Notwithstanding the above, the crux of the issue is that for alleging continuing unlawful activity, it should be shown that a person who has committed an activity which is cognizable offence punishable with imprisonment for 3 years or more, either singly or jointly, but as a member of an organized crime syndicate or on behalf of such syndicate, and where there should be more than one charge sheet filed before a competent court of law within a preceding period of 10 years, and that court has taken cognizance of such offence. Therefore, alleging organized crime, there should be continuing unlawful activity, either individually or jointly, as a member of organized crime syndicate or on behalf of syndicate, by using violence, threat of violence, or intimidation, or forgery, or such unlawful means. And thereafter, the Honorable Court has also the what is organized crime syndicate, and thereafter the facts of that case, and finally the Honorable High Court has rejected that application.
That is the oral orders. Oral order with more specification.
I don't have the copy, so I would not be aware from what is addressing.
There also section 70 warrant was issued. Here also against the present applicant, section 70 warrant is issued. Then which one is there?
Was one paragraph three on the last screen. There can be no comparison between these two cases. The applicant is arraigned as an accused in 31 FIRs. 11 of which are registered prior to the act.
But one of the, see, you are
20 after that. There can be no comparison.
the is rejected on two counts. Firstly, it would not be maintainable. Thereafter, the court has considered the merits of the case and has held not maintainable.
That was my submission. And the court has to be
That's what I am
satisfied.
saying. These are all oral orders. So, precedent and oral order would have different meaning.
That is what I pointed out. That two factors the court, that prima facie case and whether a mana fide complaint. In this, the court concludes that prima facie case is there. And without reading any FIR, any court would conclude that prima facie case is where there were 31 FIRs and 20 after the promulgation of the act. There can be no comparison between
Yes.
these two cases.
Sir, so far as the merits of the case is concerned, against the present applicant, three offences are registered, one in 2016 and two are in 2020. So far as the submission of my learned friend, that he is harping upon that there is only one charge sheet that has been there after the promulgation of the act. Answer to that submission is this way, that I day in, day out, I keep reliance on the judgment of Honorable Apex Court passing Zakir Abdul Mirajkar, wherein the law is very much clear now, para 83 and 84. There, the Honorable Apex Court has, in the case of Maputa, held that the requirement of filing of more than one charge sheet is not for the member of the syndicate, but is for the organized crime syndicate. And here,
It's against the syndicate, not against
syndicate,
every accused.
that is what the Honorable Apex Court has held in Zakir Abdul Mirajkar. So, relying upon those two judgments, even in the case of Sandeep Prakash Gupta, the Honorable Apex Court has in para 51G has held that is very much clear that if he continues committing crime,
And not to
then
wait
the state has not to wait for filing of or wait for the more than two charge sheet requirement. One another aspect, all these submissions are canvassed by the present applicant in his quashing application, which is pending before the Honorable High Court, there no stay has been granted.
Working ચાલુ ઉપર આવી હશે.
Thanks, sir.